water while you do the intro.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm really happy to have you all join us. And I'm Nipasa Pradhan, your host for today. Before we go on to today's discussion and we have our guest for today, I want to read out this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook, and also on X. So, please feel free to join us by commenting wherever you're watching us, and I will definitely tell you what is today's discussion going to be. But yes, for most of you all, thank you so much. It's been great that you join us, in these webinars. But we would love it if you can also join us, on call, conversation with us and of course our guest. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. So once you're in, you just say hello and we will be able to hear you. So, yes, today we are going to dive into this. One of the most anticipated updates in immigration policy. I think, it's been a while that we have been anticipating this, wanting this to happen, and it's finally happening. So, modernizing the H-1B program. This is a critical topic for both employers and also workers, as the Department of Homeland Security, that is DHS, has announced significant changes and has aimed at improving flexibility and efficiency in the H-1B visa process. So we are going to discuss in details today about this. And joining us today to break down these updates and discuss their impact is none other than Attorney Justin Rivera, who is an immigration attorney and an expert in employment-based immigration law. Thank you so much, Justin, for joining us once again. Really good to have you.
Yeah, thank you for having me, and an early Merry Christmas to everybody.
Absolutely. Here's wishing you too a Merry Christmas. I can see it's looking very festive out there at your home. So here's wishing you a good one, to your whole family out there.
Thank you.
And also to
Um,
yeah, and also to Wasden immigration litigation. I think I should wish them all.
Thank you. Yeah, appreciate it. Looking forward to the time off.
Absolutely. So Justin, I mean today's discussion on this topic, modernization, the modernizing the H-1B program and what to expect and how will it impact your business. So, could you tell the folks out there what can they expect from our episode today so that they stay with us?
Yeah, I mean, in terms of what this does for us going into next year, I think it's a very important changes. I mean, some of the stuff is going to be good, as I'll highlight, but some of the stuff, well, I think a lot of it is good, to be honest. So a lot of it's good, some of it's bad. One aspect of it is probably going to be very bad for specific types of employers. We'll dive into it. A big point to point out on this is the regulations themselves actually go into effect on January 17th. And a question that's already on everyone's minds is, after these regulations go in and are codified and the administration changes, are there additional changes made? Is there anything that's pulled back? How would that happen? So the impact of them is TBD. We will have to kind of see what the impact is in Congress with what the new administration wants to do. But for now, this is the playbook. This is what we're going to have moving forward, and what we're going to be dealing with. And like I said, some of it is pretty beneficial. There's stuff in here that I think is very helpful, specifically for beneficiaries. Some stuff that's really great for employers as well. Then there's some other stuff that I think is going to make third-party placement more challenging going forward. And then there's some other stuff that's honestly, it's problematic from my opinion. And I think that you might end up actually seeing litigation on it, if not on some other aspects. But we will do, as deep a dive as is permissible within the hour on all of these aspects. And hopefully everyone comes away more informed and prepared for when these regulations begin their implementation.
Absolutely, Justin, and I'm sure we are all looking forward for this to happen. I mean, long time, right? People have been wanting changes, especially with the H-1B visa system. So, yeah, we will dive right in. But before that, hello to you too, Rag. Thank you so much for joining us on YouTube. He says hello, Nipasa and Justin.
Mm-hmm.
So, also Trisha, hello to you. We are going to address your questions. Just stay with us. So,
Mm-hmm.
Justin, my first question to you would be if you could explain, how the DHS rule strengthens U.S. employers' ability to fill jobs and what impact it could have on the economy.
So I think at the end of the day, there are certain aspects of this that are great, because I think it's going to modernize and provide clarity on a system that is, for better or worse, overseen by people who are officers who are in service centers that are 9 times out of 10 making decisions that are based off of limited training materials or prior experiences. One of the biggest things that I think is going to be beneficial is the definition of specialty occupation kind of being updated. To point out this, basically what they've said now is that a degree requirement normal does not mean always within the criteria. So right off the bat, what we're establishing here is a specialty occupation can be a position that typically requires a degree in a specific specialty. It doesn't always have to require a degree. Immediately, what that does is create a more expansive definition, which in turn should make it more simplistic to adjudicate that a position is a specialty occupation. Another thing that was great that I saw was that the petitioner can accept a range of qualifying degree fields to qualify, but they must be directly related to the position. And what they mean by that is there has to be a logical connection between the degree and the duties of the position. All of that is great. I think that is very beneficial. What that does is it shows me that when the service is adjudicating these cases for specialty occupation, they are saying, okay, does this position require a degree? And are the degrees that the petitioner says are required, do they make sense in relation to what this person does? Now, does that mean that someone who has a bachelor's degree in, basket weaving is going to be able to qualify for a position as a computer systems analyst? No, there's no logical connection there. But what it does is it allows for a logical expansion of those fields to where it makes sense. And what I mean by that is this. In the previous administration, when the Trump administration was first in, there were denials that were seen for IT related positions, where they basically curtailed it to such a narrow view that they basically said, if you don't have a degree in computer science, you can't do this job. You can't hold this position. And modern day, that's ridiculous. Obviously, people can do those types of jobs based on their degrees, even if the degree has a mild variance to not just being computer science. This opens that door, which puts us in a situation where hopefully the adjudications for specialty occupation make sense. And so when there is a case that's denied, there's a rational explanation as to the justification for the denial that isn't something as simplistic as you can only hold a degree in X to qualify. So I think that's good. I think that that's going to help people moving forward. Um, Another way that I think that you're going to hopefully see companies benefit is the codification of deference for prior approvals. What that means, just in a non-legalese way, is if you were on an H-1B and you're filing a new H-1B and there's no big change, you should get your case approved based on the deference to the prior approval. Absent a material change or some new evidence that USCIS did not have at the time of the previous adjudication, it should almost be a rubber stamping. So what that means is, obviously, we know there's a significant visa backlog. There are people who are
Mhm.
on H-1B now or have been on H-1B for several years that are probably going to continue to be on H-1B. If they are remaining with that same employer and they're not having a significant alteration to their petition, their extensions should just be streamlined, which is great. Again, we don't know what the impact of that's going to be from the new administration, but in theory, right now, that should be what we see. Other small things were the itinerary requirement has been completely removed, which is great. I don't think it was something that was really given any consideration now anyway. Um, the acceptance of matter of semio solutions, without going into too much detail, basically really clarifying, when you need to file an amendment versus when you don't need to file an amendment. That's great. Entrepreneurs saw a huge win for them in that, they are codifying the ability of company owners, to sponsor themselves for H-1Bs.
Themselves. Mhm.
So that's a big benefit as well. And then there's some other stuff as well that we can kind of get into that's more beneficiary centric. But I think overall those changes are going to help companies make it easier to bring people in on an H and keep people on an H.
Right, right. And these changes are only effective from January 17th. So people who have applied before that date, it's not going to affect them, is it?
It should not. There should not be any impact from it until that 17th date, range of implementation. Um,
Okay.
Inevitably, when there is changes, though, you're going to see a period of transition where things
Hmm.
are weird, because attorneys, we play within the rules that are provided to us, but a lot of what we do is related to precedent. What have we seen before, and how do we use that information moving forward? So you may see some
Hmm.
weird RFEs come out initially as both the petitioners and the officers begin to kind of play within the rules of the new changes. But I'm hoping, at least for these perspectives, it'll be a positive change.
Absolutely, absolutely. So we'll quickly take up Rag's question. He's asking the H4L2 bundling with H1L1 ends on January 18, 2025. Will this affect first time H4 or L2 applicants, with regard to, I guess he's saying, I-539 and I-765?
So this kind of is a remain to be seen thing. It's not. I don't necessarily think you're going to see an uncoupling of the adjudications. I would wait. I would wait and see what happens closer to the actual end date of this administration, to see if there's anything else that's put out or provided. I will definitely say this. As I've spoken about before, I think a big idea of the new administration is going to be delaying things where they can to make processes more difficult. And one of the easiest ways that they can target that is by splitting the premium process benefit for the adjudication of H4s and L2s. Um, so it wouldn't shock me if that's something that we're dealing with. But to go the other way, there is a rational benefit to USCIS in keeping the policy in place, especially when you look at it when it's coupled with the idea of the deference that's going to be provided to previous extensions. I think that if you just are already going to approve the H and you can approve everything else together in unison, you get the case out. And for the officers that are trying to work through large caseloads, that's probably going to be a big consideration for them. So I would really say I would wait and see. Yeah, unfortunately, the first time filers, that's going to be a problem, right? Because for work authorization, there's already been guidelines put in place that, help people retain work authorization, even though their I-765 is still being adjudicated. And
Mm.
those LPL2 and the H4, they each have their own classification for that. So people with extensions, they're going to be in a better situation than people it's a first time. If it's a first time and you're looking at the complete unbundling, if you're applying for an H4, you're going to have to wait. And you're going to have to wait and look at those process times. That also being said, I wanted to sneak in at some point during this conversation that I did see that the Vermont Service Center has announced layoffs recently. So they're going to be laying
Okay.
off people, which is going to likely slow down processing even more. So I think that that's something to work into the calculus as well, which how you explain to me that an organization that can continually raise fees has to lay people off, don't really understand. But I don't understand their business model in the first place. But yeah, I would definitely say, to answer your question, if they do actually put the kibosh on the unbundling, first time filers aren't going to be in a great situation, because they're going to be kind of going back to how things were, in the late 2000s to early 2020s, where you're looking at those 5, 6, 7 month delays.
Right. Thank you so much for taking that up for Rag. And Rag, thank you for participating with your question. We would really love you to join us on call. Why not call us on this number 425-436-6335, and the access code is 988888. And this goes out to all the viewers out there, including Ravi, Trisha, and yes, Rag as well. So yeah, Justin, let's move on to my next question to you is, how does the modernization of the H-1B visa program redefine specialty occupations, and what does it mean for both employers and employees? You said this a little bit in the introduction, but if you could elaborate a little bit.
Yeah, so kind of, piggybacking off of the first my previous, statements, the expanding the definition so that you're not really nailing yourself to one specific degree type for any sort of position or field is fantastic. It's definitely a positive. So that should be helpful for employers, because it's going to give them an easier roadmap to showing that a position is a specialty occupation. You know, our company normally requires a degree to do this, and these are the degree fields that are related. As long as there's a rational basis between the two, should be able to move forward without too much of an issue. So that's the good part for the petitioner. And the good part, I think, for the employee is it gives you a little more wiggle room in terms of what it is you're doing and how you can qualify for the H-1B. Because we also got to look at it from the prism of this. The components that USCIS is analyzing are supposed to be, is the position a specialty occupation, and does the individual have the requisite work experience or degree or combination required for the position. And so I think that helps the employee now, because you're not stuck with the idea that you just have to have a degree in, let's say, computer science in order to do an IT related job. Where I think that the modernization is problematic is in related to third party placement for the specialty occupation definition. There is language included within this new guidance within the regulation that basically says if someone works at a third party location, the third party must be providing work that is in a specialty occupation. And as a result of this, the idea is that the third party's requirements for the position are most relevant in determining whether or not the position is a specialty occupation. So I can understand the logical conclusion from this, which would be, okay, yeah, if the person's working at Sears, Sears has to require a degree, in order for the person to do the job. Otherwise, it doesn't make sense that it's a specialty occupation. That's the logical thing. Here's the problem with that. Third-party placement requires you putting someone at a client location. That client is not bound by the same conditions as the petitioner in order to, service the employee. The reason why they have a contractor is they don't want to deal with having an employee. So the first issue becomes, is the client even going to furbish that information as part of the process for the petition? Like, let's say, for example, an H-1B employee is working at Apple and they move to Google. Well, part of that is you file, an amendment to move the person to Google or Apple or whatever. Is the manager of the project going to immediately issue a letter from the company on company letterhead saying, yeah, this is a position with our company that requires a bachelor's degree in XYZ and turn that over? Or are they going to say, yeah, I'm not giving that right now. Get him over here and let's start him working on the project? So that kind of becomes, I think, the first problem is I think this is a way to almost backdoor the reintroduction of requiring in-client letters. A practice that was definitely used ad nauseum by the Trump administration to deny cases because let's work backwards from this. If you can't provide the in-client letter to show that the position requires a degree within a specific specialty, then they can deny your case saying they can't establish specialty occupation. So that's one issue that I look at and say, that could be problematic. Let's say you even do get the client letter and you provide it to them. USCIS is adjudicating the case and they look at it and say, well, this says it requires a position in X, but I used my favorite tool as an officer, Google, and I went on Google and I looked at the company and I looked at job postings for the company. And the job postings for the company online don't say that this position requires a degree in X. It just says it requires a degree. Well, now they're going to issue a request for evidence and say, well, we can't tell if they actually have a position that's required in this specific specialty. Then you're getting into a fight between them with like, okay, just because you saw something online doesn't mean that it takes away from the evidence that we presented to you. All I'm saying in this is what I don't like about that is you're opening up the door for evidence that has to now be provided that previously wasn't necessary, because it, in my opinion, is kind of outside of the scope of what should be asked for in terms of who makes the decision on whether or not this person's position qualifies. And that, I think, will probably lead to some bad adjudications. And unfortunately, we'll have to wait and see how that is dealt with because you're going to have to look at what the officer's decision making is. The benefit, obviously, is that they have to at least issue a request for evidence. But even so, that's not something that I saw that I was a big fan of. And I do think that it could be problematic for employers, any employer that's doing third-party placement.
Right, Justin. Thank you so much for covering that in detail. And you already covered, I think, half of my next question, where I was almost getting to, ask you to tell us about the main benefits, but also if you could highlight and also challenges you've already, um, you know, um,
Yeah,
highlighted for us. Yeah.
yeah, no
So,
problem. Yeah, so some of the other things that I saw before, because I'm trying to be positive before I'm negative here. Some of the other things that I saw that were beneficial. The employment authorization expansion for people that is on what's called cap gap. So cap gap
yes.
is this idea that, if you're on an F1 and you're working and you get an H-1B approval and you file an H-1B change of status, the cap gap will allow you to remain in the United States and continue working legally up until the date where that person changes status. That's great. But before, cap gap ended on October 1st. So if you
Yes.
were someone who had a change of status that was filed but was not approved on October 1st, you lost your work authorization. You're able to remain in the United States because you have a timely filed change of status, but you can't work. The problem there becomes if the company can't have you working, then why is the company going to keep you? And obviously, there's things that you could say, well, why didn't you do premium? Maybe there's an
Mhm.
RFE. All of this is to say it was an issue, which would lead to people basically front loading the adjudication of change of status cases for October 1st because everyone knew
Right.
that those people's cases had to be put at the front of the line. What has changed is they have now moved that cap gap authorization all the way to April 1st of the
Of the
following year.
next year. Hmm.
Yes. And that's a phenomenal benefit because what it does is two things. It removes the stress from the employee in worrying about having work authorization, and it removes the stress from the service centers in having to front load their review of petitions that are change of status. Hopefully, at the end of the day, it provides a more streamlined process and less issues. Um, Another thing that was really good is they are allowing you to change the start and end date as the reason for a denial if a case is denied and then subsequently approved. And I know you're thinking, okay, how is that much of a benefit? A motion to reopen takes forever. A motion to reconsider takes forever. An appeal. The benefit there is there have definitely been scenarios where someone ends up with a denial and then it's appealed. And then let's say it's on their cap exempt H-1B, their first H-1B where they've gone through the lottery. Well, if for whatever reason that case ends up getting reopened, it could, in theory, be denied if the end date had passed. So, because of that, you had seen situations where perhaps USCIS had said, yeah, we made a mistake. We're going to reopen the case, but we can't approve it because the end date of the validity period that's been requested on the petition is passed. Now, what they're saying is instead of doing that, what we'll do is if we reopen the case and the end date is passed, we're going to send you a request for evidence and basically tell you, give us a new LCA, give us your new start and end date, and we will honor it on this petition. So I think that's beneficial. It should be helpful. Will it help a lot of people? Probably not. It's probably going to help a very rare sliver of people. But for that sliver of people who the benefit is they, don't have to go through the lottery again. They have an approved H-1B and they can, file an extension and maybe get their perm sponsored. That's a huge deal for them. So I think that that's great too. The other thing that I thought was good was they expanded the definition of nonprofit. Basically, they changed it to say, instead of saying the primary reason of the entity must be research, it's now fundamentally a fundamental activity. So I think what the whole purpose of that was is they want to expand the scope of nonprofits being able to use H-1Bs. And obviously, if you're not aware, if you work on an H-1B at a nonprofit, if it's a cap exempt employer, that means that you can work there without having to go through the lottery. So that's beneficial. And I do think from my reading, the goal is they do want to expand the ability for nonprofits to have access to these employees. Because the regulations itself, it actually says, we're not worried about people cheating the system because we know that this is research is very competitive already. So the fact of the matter is they already want to hire the best and brightest. So let's give them the ability to do that. The last thing is the beneficiaries can be cap exempt even if they are not employed by a qualifying organization, as long as they spend half of their time providing essential work to support a fundamental objective of a qualifying organization. So what that means is, theoretically, you could be placed at a client location as long as it's a nonprofit organization and more than 50% of your work falls within that parameter and be cap exempt. So I think all of that stuff's great. I think it's very positive, and I'm very hopeful that it will be used in the best way possible, and that there's no one trying to do anything untoward or fraudulent to get within that nonprofit parameter. Just the real quick, the bad the entrepreneur stuff. I apologize. I feel like I'm running on time so fast. The entrepreneur stuff. Yeah, the fact that entrepreneurs can now sponsor themselves for H-1Bs. That's a positive too. And that it's been established before, but now it's been clear cut. That's great. The bad stuff, bona fide employer. It seems like they've basically changed the definition of employer-employee relationship to bona fide employer. Under the guise of bona fide employer, they are attempting to reiterate the idea that contracts or similar evidence to confirm the position is bona fide are required. My reading of that is, if you haven't already, be ready if you're a third-party company to be asked for contracts and work orders between everyone in the succession of contracts. So if you're going from petitioner to vendor to end client, they're going to say, give us everything in there. So will that stand? I'm not sure. We'll have to see, but that's not something I like. A random one, petitioner needs to be have a legal presence in the U.S. and be amenable to service of process. I think that's clearly coming off the basis of they want to try and hit employers for fraud. And in order to do that, they have to be able to go after them. So they want those people in the U.S. Thing that I didn't like about the beneficiary ownership, the initial approval can only be 18 months. And the first extension can only be 18 months as well. What that basically means is they want you to prove to them that this is legit that this business is legitimate, probably that it's growing, bringing in revenue, bringing employees. I would say it would not shock me if we saw a lot of denials between the first approval and the first extension, meaning that first extension, I wonder what they're really going to look at to show that you qualify for the second 18-month extension. We'll have to see. Lastly, before we move on, we can talk about this in more detail later, but I know I am going over on time. The really bad aspect of this is the codifying of site visits and noncompliance. Before, site visits were they were not mandatory. They were, you choose whether or not to participate in the site visit as part of the program. Allegedly, under this, they're now saying that you must comply with site visits, and failure to comply can actually lead to a denial of an active petition or a revocation of a prior petition. This is different than before, and it's going to have to change how everyone looks at things. But I'm going to come out and just tell you guys right now, because the language was in the regulation. The language within the regulation clearly states that based on their data, non-compliance rates were found to be higher for workers placed at off-site or third-party locations as compared to workers placed at a petitioner's on-site location. They have initially claimed that close to 19% of their investigations have yielded a fraud finding. And that's non-compliance. That's where people are able to opt out and not participate. Now that the participation is mandatory, coupled with their already stated conclusion that more fraud is committed at third-party placement, it will be open season on third-party placement. That's going to be a huge part of, I think, regardless of the administration change moving into next year. It will be a huge thing. So, as I've said before, and I'll say again here, you really need to make sure that you're ready for that and that your employees are ready for that. But yeah, that's pretty much it in terms of what everything is, as kind of an overview of what's good and what's bad. There's some other small stuff in there that I'll try to get to, but I think those are the big points to highlight of what will be beneficial and then what will be challenging.
Thank you so much, Justin. I mean, that was a detailed coverage, and I think very important points that you've highlighted. And folks out there, thank you so much. And if you have resonated, please let us know in the comment section. And also, you can join us on this conversation by dialing the number that's displayed on the screen. And so, Justin, let's go on. And I have my next question, and that is, what are the conditions under which H-1B holders with controlling interest can qualify, and how does this impact their ability to start or lead businesses in the U.S.?
Right. So this is again one of those positive things. Essentially, they're saying that individuals who are beneficiary owners, and a beneficiary owner is someone that owns a controlling interest, which they have defined as more than 50% or a majority of voting rights, it's permissible for that individual to sponsor an H-1B for themselves. The purpose of this, as stated in the regulations, is they want to give entrepreneurs the opportunity to essentially open new businesses in the United States, because opening new businesses should lead to job growth, right? You open a business, you hire employees, that job growth helps the community. So that's their basis or point. What is interesting is, and they even admit in the regulation, is there's still a further need for guidance kind of on how you qualify for that specialty occupation as the owner of the company. I think there's language out there right now that says something along the lines of more than a certain amount of your duties, maybe it's 50%, qualify within that specialty occupation parameter. But what that might lead to is a bit of confusion over what kind of positions are and are not a specialty occupation. I mean, I think obviously if you're going to be running a company that has 10 or 15 employees, and you're doing high level, let's say IT work or healthcare work or something of that nature, you're probably going to be able to show that you require a specific degree. The things that might be more complicated are the more recent technological developments, like artificial intelligence, things like that, where there's not as much prior guidance to show whether or not the person qualifies. So we might see pushback on that with RFEs, but I'm not super worried about it. At the end of the day, I definitely think it's beneficial. I think that it's great that this is done. And I think that it should lead to people, doing the sponsorship, being able to be on an H-1B while having the organization, while beginning to start up an organization, and it should be helpful. As I said before, my only caveat to it is only approved for 18 months, and the first extension is also only approved for 18 months. Uh, Most people know this. A lot of businesses fail. That's just how it is. You start a new business, you're not able to generate revenue. The business isn't going well. The business goes under. Whatever. Only giving someone 18 months to then establish that the company should continue because it's experiencing growth or whatever. I am a bit hesitant as to what those adjudications are going to look like, because I don't know what it is that the service centers are going to think shows that the person qualifies for the extension. Now, let's look at deference. If we're still implementing the idea of deference, the original petition and everything's the same for the extension, should the extension be approved? The thing about it is, you can see by looking at the language that the reason why they have these short approval notices is they want to deal with fraud. They want to stop the idea of someone saying, I'm going to create a company for myself because really I just don't have a job available and I'm on an H-1B. So I'm
Mhm.
going to start, Jay's Consulting Inc. and open the company and file. And now I'm going to be back on an H-1B. And once that time's done and I find another employer, I'm just going to file that, because that's not
Yeah.
the underlying purpose of this. The purpose is to have people open legitimate businesses. So I think overall it's great. I think that people that fall into this category of controlling interest, the more than 50% of majority voting rights, they're going to be able to successfully get these H-1Bs. The thing I'm really interested in looking at, though, is what ends up being the approval rate of those initial extensions.
Absolutely. I think we all are looking forward, and I really hope that these changes are going to benefit most folks out there. And
Mhm.
we also hear that people who are going to be paid more, like they're going to select people on wage levels, right? If they are going to be paid more, they're going to be selected first. Is it going to be like that, Justin?
So, I mean, here's the thing about when you're talking about the wage levels for the H-1Bs. There's this idea floating around about in the lottery, kind of applying a weight to what a wage is going to be. To saying, if you're filing a position at level 3, then you get accorded more weight than somebody whose position's at level 1. I haven't
Mhm.
seen the actual implementation of that coming down the pipeline. I also think that it would be much harder to do, because the way the system's set up now for the lottery is it's beneficiary centric. And what that means is you enter a person in, and no matter how many times you enter that person in, their number rate is 1. It's always 1. So 7 petitioners can sponsor for a person, but the person is the person for the rate of selection. It's just 1. How does that work if you then bring in a weighting system with the levels? Are you saying, okay, we've selected one who put the highest amount of money, and then you go to the person that has the highest amount of money? I'm not sure. And the other thing with that is, what happens with actually making those changes within the system? Now, before, all you have to do now to register, very easy. You create a petitioner page, you enter the beneficiary's information, you sign, you pay the $10. Or actually, it's going to go up, right? So the amount's going to go up now, but you pay the amount. Now you're adding in a labor condition application. So now the LCA is going to have to be certified. You're going to have to know the position and where the person's going to be working. And remember, they can't start working for your company in this position until October 1st. So you're adding in a lot of calculus to a system that's already kind of rudimentary, and they've already come out and they've admitted that the way the system is now is working. They actually came out and said, we're not really trying to mess with this. It's worked. Registrations went down last year, so we think the underlying goal, which is to remove the fraud that was taking place, is gone. I'm not sure they would then subsequently go back and then tack on new issues. Now, where you could see wage levels as an issue is in their relation to qualifications for a specialty occupation. And what I mean by that is, we saw a lot of in the previous Trump administration of it's the level 1 wage issue. Basically, the argument coming out saying, if it's an entry level position, how is it a specialty occupation? How does it require a degree? And I think that's where you saw people basically start to say, we don't want to deal with that issue, so we're just going to put the wage up. We're going to go up to level 2 or up to level 3, and because we don't want to mess around with level one at all. Could I see that coming back in a big way? Absolutely. So I definitely think that that's probably going to be something where if you're a petitioner and you're filing a level one wage for someone on an extension, someone that's already been with your organization for 3 years, and you're saying they're still a level one, they're going to stay there, that could be an issue for you. The other thing would definitely be, looking at someone who's in a position where they manage or supervise others, people that create things. If you're creating technologies, I don't know if you can be level one and create technologies, or they don't at least, and then you have to prove it to them. So that's where I think you'll probably see that come in more. And then who knows with the next administration, if they want to come out and figure out a system, devise a way to increase the wages further, then we'll have to wait and see if they do.
Okay, okay. Thank you so much, Justin, for addressing that and for the detailed explanation. I think we should address some of the questions from our audience now. Rag is back with another question, so let's take that up first. Does USCIS still use Dun and Bradstreet data, and how imperative is it to update location details in DNB?
Yeah, I don't really know. I mean, it's probably a tool that they still can and may utilize. So I would say for those that do, continue to update it. Yeah, but it's not something that I have readily available off the top of my head. But I would just definitely say if it's something that you have been using already as a tool, just continue to use it, and expect if USCIS has used it with you previously that they will prospectively.
Okay. Now let's take up Amay's question. Hi, Amay. Thank you so much for joining us. Let's take it up. I am on H-1B and working as a contractor. My spouse is on H-4 EAD and she's working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
Yeah, so generally speaking, no, it won't impact her. The F4 or the H4 is conditioned upon the maintenance of the primary status. What that means is the H1B holder um, the H1B holder has to maintain their status, and by proxy of that, the H4 holder is able to show that they qualify as long as they meet the underlying guidelines, and that's if you're a spouse, marriage, that can be proven. So if you move to another employer and you're still maintaining your H1B, it shouldn't be an issue. There shouldn't be any problem with transferring. Now, here comes the issues associated with that, though. Just off the top of my head, when you move your H1B, you transfer to another employer, your period of approval, your validity period is going to change, right? Your validity period is no longer going to match your spouse's because your spouse's validity period was subject to your previous H1B. What that means is you have to be mindful of the fact that when her H4 is set to expire, she needs to file an extension, and it's going to be an extension that's probably well before your extension. So that's issue one. Have I seen that be a problem? Absolutely. I have seen people who come to file their extensions that have moved to an employer, and that H4 has been invalid for 6 or 7 months. But they didn't think about it because they just thought, okay, the H1B transferred, we're fine. So that's one thing to think about. And also to think about as well, if you're filing that transfer, maybe just file an H4 with it as well for her, just so that you guys have those same validity periods for your approval notices. So that's one thing to consider. The other thing to consider is this: in very rare circumstances, so I can't do an exact percentage, but very rare circumstances, I've seen where someone moves to another employer with a transfer, that the H1B employer is going to withdraw the H1, right? Because they don't want you're not working on it anymore. In very rare circumstances, I have seen that H1 withdrawal trigger the H4's withdrawal. And basically what happens is USCIS says, well, that H is no longer active, so the H4 is no longer active. That's wrong from a policy perspective, but in a legal perspective, it's wrong. But here's the problem with that. You have no grounds to attack a withdrawal. If an H4 is withdrawn, it's not like a denial. There's no appeal. There's no ability to reopen or reconsider. Withdrawal is withdrawal. It's gone. It's done. So you have somebody who's moved to another employer and started working, and then they or their lawyer receives a withdrawal for the H4, and they're like, "Why did this happen?" Well, now you're in a position where you have to file a nunc pro tunc H4, basically saying you should forgive my time out of status because you guys screwed up. Is it going to get approved? Probably. Why wouldn't the government approve it? I mean, they're the ones that screwed up. Is it going to get approved? Great. But what about the problems associated with that? If your wife's working with an employer and she's no longer in H4 status, is the employer going to come back and say, hey, you can't work with us, you're fired? You know? So avoiding that issue is just, again, filing the H1 and H4 together and just filing it for peace of mind. Is it necessary 100%? No. Can you do it just to avoid
Okay.
those two scenarios? Yes.
Okay. There you go, Amay. Thank you so much, Justin, for taking them up. Amay, I hope you got your answer. Well, Rag is back with another one. When is FDNS visit done for L1H1, and is it on time or periodical? One time or periodical?
So yeah, I will say, Raj, I'll answer your question, but I do want to say if we could get to Trisha's question as well, because she had asked one at the very beginning. I think that maybe we could get to that too and speak with her as well. But
Yes.
okay,
So
that'd
sorry,
be great.
Trisha, for leaving you out and your
It's okay.
question out.
She got in at the very beginning, so I want to reward
Yes.
that participation. Um,
Let's take it up. Yes. Our company
okay.
heavily relies on H-1B employees for specialized roles. So, if the program becomes stricter or more selective, how should we adapt our hiring practices to ensure compliance and still get the talent we need?
Yeah, so I mean, like I said before, I don't think that the way that they've changed specialty occupation, the definition is actually harmful. I think it's positive. I think it's beneficial. The way that I don't like it is obviously the notion that if you place someone at a third party, that third party has to make the determination that the position qualifies for specialty occupation rather than the actual employer. Um, but that being said, I think regardless of that, you're still going to see an administration change where the new administration is going to come in and try to tighten guidelines, even if they've been changed. My thought process for that is this. I would probably, if I could do whatever I want, if I ran a company that hired H-1Bs and I wanted to ensure my continued ability to hire people in specialized positions, what I would probably do is make sure that your hiring practices are up to date with compliance for the definitions of specialty occupation. So what does that mean? Well, when you make positions publicly available, you post them, right? Most of the time when they're posted, you can access them on the internet through, LinkedIn or Glassdoor or anything like that. I would consider ensuring that those requirements for the position show that the position requires a degree in a myriad of fields, maybe going as
Mhm.
far as to listing some of those fields. You could maybe tack something on like this is not an exhaustive list of the position of the fields that are acceptable, but are the position or the fields that most likely align with the position, something like that. Long story short, doing that kind of gives you the opportunity to say at the outset, like when we're hiring, we're only considering these kinds of degrees and
Mhm.
people with degrees in this field because that's what we know is needed for the position. So that's one thing I would do. In your hiring practices proactively, I mean, if you already hire people with degrees and you're continuing to do so, you should be fine because one of the ways you can show evidence of specialty occupation is showing that similar individuals within your organization hold a degree in a
Mhm.
specific specialty. If you're able to produce that evidence and show, look, I have 17 programmer analysts. All 17 of my programmer analysts have degrees that are logically related to the roles that they're performing. I'm hiring an 18th programmer analyst. Makes complete
Mhm.
sense that you're showing that requisite requirement. So I think those are ways that you can do that. And I mean, honestly, if you have the ability to do so, I would just start doing it now. You have a little bit of time and opportunity to do that, so I would say prospectively try, and hopefully that aids you in the event that you're filing in the future and you're having to deal with an RFE or a notice or whatever. Sorry, I dropped something.
No worries. But yeah, thank you so much for taking that up. And Trisha, thank you so much for your question. If you have more questions, you can keep commenting. Now, if we can, let's go on to some of our questions we have. But if you would like to take this by any chance
Yeah,
from Raj.
absolutely. Raj, thank you for coming back, man. FDNS done for L1H1 is it one time or periodical? Mostly it's going to be one time. Um, and I say mostly because unless they have a real reason or justification to make another visit, they're gonna try and empty the clip on the first one. So they're going to
Mhm.
want to try to go and procure as much information as they can uh, in person, and they want to physically talk to you and get whatever information they can. The regulations are basically kind of saying, um, when they talk to people now, they want to talk to the person, they want to talk to the person's manager. So
Mhm.
already they're with these new regulations, they're saying, well, not only do we want to talk to you, we need to talk to your manager. And if you're at a third party site, that means we need to talk to the manager at the third party site as well. So right out of the gate, they're basically saying, you're not heading us off by just saying, just talk to me, or just talk to my attorney. They're going to say that these other parties need to be involved as well. Now, does that remove the ability of you to have an attorney handle the answers for you? No, it doesn't, because you can have representation. So I would still marry myself to the idea that if you are a party to a site visit and you are someone who employs peoples on H's and L's, you need to make sure they're trained, and you need to make sure they know what to say and that they want to move things, first off, to a record, a platform where there's a record, meaning,
Mhm.
either you can do a call that's recorded or you can go on email, and that you want to have representation there. The reason why I say that is I have seen a decent amount this year of officers who have formed conclusions based on statements that the employees are saying they did not make, or they are based on statements that do not align with what they were intending to say. But you have to understand, these FDNS officers, and I will say this until I am blue in the face, their goal is to find fraud. They want to find fraud. They're not coming to be your friend. They're not coming because they're just doing their job. They want to find fraud. The more fraud they find, the more they justify the existence of their job. So that is their purpose, to find fraud. And so the reason why I say, involve an attorney and get things on record is you want to make sure that everything has been properly done and all the information that's been provided is legitimate and related. I'll give you a perfect example right now. We just engaged with a company who was completely compliant with the site visit. They provided everything to the officer up front. They provided the additional documents that the officer had emailed them for the first time. And they even provided documents for another employee who was allegedly not related to this site visit at all. Just another person they threw in and said, hey, while we're here, give us this guy's docs, right? In no way related to the petition. They engaged us because the officer has now come back and asked them again for not only the information that they provided, not only the information in their statements, not only the information for the additional person. They now want a list of every employee in their company, every project that person's working at, the wage the person is making, the person's supervisor at the third party work site, on the form, on a detailed form, along with all of these people's approval notices and all of their labor condition applications. So, why am I telling you this? The purpose I'm saying is this: if you don't push back against FDNS officers and say, okay, that's enough, I've given you everything that I need, or if you don't at least know your rights to provide what is and isn't actually necessary, they will take everything. They will take everything available to them. And I'll tell you this: if they provided that information, those documents, they will turn around and subsequently investigate every person on that list. And you got to remember, the purpose of this FDNS site visit is supposed to be related to compliance with the petition at issue. So that's one person's petition in relation to one H-1B that has now been extrapolated to include every employee on a non-immigrant visa for the organization. And what I mean by that is not just your H's, your L's, and your F1s, the whole organization. And that's a company that was complying at a timeline where they don't have to comply. So imagine what that's going to look like next year when instead they're going to say, well, I'm going to threaten you with non-compliance and just deny your case.
There
So
you go,
yeah,
Rag. Thank you so much.
it should be one time, but what will not be one time are the amount of email correspondences that the officers will subsequently send you.
Mhm. There you go, Rag. You have your answer. Thank you so much, Justin. And we have a couple more questions from our, uh, on YouTube. So let's take that up. Control, if you could display, please. So this is from Harsh Bansal. This is asking, hi, hi all. My wife's H-1B extension was approved last month, but we haven't received the original sorry 797 approval notice. So her employer provided courtesy copy I-797C. Can we use courtesy copy for the Dropbox appointment in India? We need to travel urgently next month. Really appreciate the help.
Yes, you can. I think that the old school practitioners would say that you must carry the original copy with you. That's not necessarily the case anymore. You can use a copy both at your appointment and when entering through CBP. At the end of the day, we're in a digital world. All the information that they need is already accessible. You're not going to really be able to pull a fast one on them by presenting a copy that's somehow fraudulent or been marked in a way. So you're fine. If at worst, if you're asked about it, explain you never got the original, and you should be okay. You can always request another copy. Thank you, Raj. Happy holidays. You can always request a duplicate. You do have to file for it, and it does cost you money. But if you want peace of mind, you can do that. But at the end of the day, you're completely fine with using a copy. As I tell people often, the only place that I have dealt with pushback lately with originals is the DMV. The whatever department within the state that issues driver's license. For whatever reason, sometimes they push back and say you need the original.
Okay. Thank you so much for taking that up, Justin. Now let's go on to our next one. Control, if you can display our next question. How long does it take to get a receipt if I have filed an H-1B transfer in premium processing and new employer sent the FedEx on last Friday and it dispatched this Monday, still
Yeah.
like 5 days and they don't have a receipt number?
So this isn't completely surprising. As I said earlier, the Vermont Service Center is going through layoffs. Other service centers are going through layoffs as well. If you filed your case right now, it's the holidays. A lot of people are taking vacation time, which lowers the numbers of officers that are available.
Mhm.
So yeah, I wouldn't be shocked if you haven't received the receipt yet. Here's the thing with premium, you get a digital courtesy copy that's going to go to the email address that was provided in the petition. So if you G28'd, then that's going to be the attorney. If you didn't use an attorney, it should go to whoever the signatory for the company is or whatever email address they put on there. So you should be getting something. 5 days is a little vague. I want to be clear. 5 business days matters. 5 days that includes a weekend, you don't count that. That's not part of the calculus. So remember that when you're thinking about this process. If you sent a case on Thursday and it got there I sent it last Friday. Wait, sorry. Sent FedEx on Friday and it got there on Monday. Oh, sorry. So you did answer. So it has been there for 5 days. So yeah, 5 days is pushing against a long time to not get a receipt notice, but it's not entirely surprising. I would
Mhm.
maybe check and see if you did get a courtesy copy. If you don't have a courtesy copy yet, do this. I cannot stress enough. Easiest way to make sure your case was accepted or not if it's been a while. If you filed with checks, see if the checks have been run. If the checks have been run, you're good to go. It means USCIS has accepted your case. If you filed with a credit card, see if the credit card payment has come out. If it has come out, they've accepted your case. And so at least you have the peace of mind, even without the receipt number, you know that the case has been taken in. I had a case recently that I think it took me 6 or 7 business days to get a receipt. And what happened was the night before I got the receipt notice, I got the alert on my phone that the credit card fees had all come out. So that's how I was able to tell. So I would say look at that. Look at the checks and then or the credit card or whatever. If you get to day 8 and you have not had those checks come out, default thought is rejection.
Okay. Well, there you go. I think that's it for today. We should wrap up our show, right, Justin?
We
Since
can take that
you
last question if you want.
cool, so let's do that
If you
then.
don't mind.
Control.
If you want to get off and stuff.
No, I was just worried if you're in a hurry. So H-1B visa refuse status. So my Dropbox appointment was on December 12th, 2024 in Chennai. The status changed to application received on December 12th. And on December 13th, it has been updated to refused. I'm yet to receive intimation on when I can collect my passport back. which will likely have the slip proving more details on the next steps. This is my third time stamping, not sure why it shows as refused. Any insights?
That's very interesting. That's a very interesting question. So I obviously tell you by the default, most times when the consulate takes your passport, they're going to approve it, even if they need to address additional information. So the fact that it changed to refused is obviously puzzling. What's more puzzling is that you haven't received any correspondence from them in relation to the visa refusal. That's very shocking. Most of the time, you're at least getting a 221G when you walk out of the consulate that gives you an email address or something to reach out to them. So what I would say is if you're trying to be proactive and do something, obviously we all know the consulates don't pick up phones and talk to anybody. That's never something they're going to do.
Mhm.
Usually through a little bit of perusing, you can find their email address, right? Other people have gotten it in connection with 221Gs or whatever. And you should be able to find that email address that way. What I would recommend as your first step is emailing them and just giving a very basic explanation. I would honestly front load it with, you guys have my passport. So I think that I would start off with saying, you have my passport. I need my passport back if my visa is refused. And I also need an explanation as to why my visa was refused. They're obligated to provide you with that, and they're obligated to provide you back a copy of your passport. So I would do that, and then hopefully that works out. And then once you get the basis of the refusal, you can work backwards to see if you want to apply again or if you want to use LegalNet or whatever avenue. But yeah, step one is at least getting a copy of that doc, and that would be my starting point because nobody's going to answer you anyway. The other option you would have is if you have a representative, if you've already lived in the U.S. and had property in the U.S. If you have a congressional representative, you could try reaching out to them and explaining. They love to help, and the consulates are more responsive to them than they are to everyday people. So that would be my other option.
Cool. Thank you so much, Justin. And I think, folks out there, you can also consult with attorney Justin Rivera and you can contact him and his phone number and his email address. So his phone number is, um, if you could just put it on the screen, please, so that folks out there
Oh yeah.
can note it down. Control. So the phone number where you can contact with attorney Justin Rivera is 844-592-7336. Please note it down. It's there on the screen. And you can also email him support@walsden.law and go visit www.walsden.law to get to know more about attorney Justin Rivera and, of course, Walsden Immigration Litigation. And also, please do not forget to check out Walsden Immigration Litigation on LinkedIn. And last but not the least, it's the holiday season, Justin, and I'm super excited. I'm sure you two are. So here's wishing you, your family, once again, a very Merry Christmas and, of
Hmm.
course, happy holidays and wishing you more love, abundance, and blessings this season.
Thank you very much. Merry Christmas to you and to everybody that was on. I hope you all have a great holiday, and I will see you all next year.
For sure. Thank you so much, Justin. And thank you again, once again, for this very, very insightful session. And if you have anything more to add, before we say bye, you might as well.
Yeah, no, I'm gonna get out of here. It was a pleasure.
Thank you.
All right, y'all have a good one. Bye.
Thank you. Thank you so much. You have a good one too. Great day ahead. So, folks out there, thank you so much for joining us today. It was great having you. Really lovely. And Rag says, thanks for this episode and happy holidays to you both. Happy holidays to you too, Rag. Thank you so much for joining and stay with us. Watch out our space here on Immigration and Jobs Talk Show because we keep having interesting discussions on different topics, all related to immigration and jobs. And also, we have another upcoming show coming up, Daily Immigration Dose, which we do with which I and my co-host hosted, and that's with Sam. So look out for it, 4 p.m. Eastern Time. And of course, please do not forget to like, share, and subscribe to our channel. You can also write to me, call me up, or WhatsApp me. And my phone number is 408-335-6444. You can email me at nipa@staffingly.com. So for now, this is it. Y'all out there have a great day ahead and see you again here on Immigration and Jobs Talk Show.